Good morning, everybody. Welcome to the first of the Bowman's Employment Law Updates. For those of you who don't know me, my name is Damant. I'm a partner in the Employment and Benefits practice, have been for some time, and I'm going to be facilitating today's session. Just before we kick off, just a couple of protocols around webinars. You will see that we've disabled the chat function, so you won't be able to use that. But there is a question and answer function that you will be able to direct questions to the panelists if you need to or want to, and I will try to facilitate answers to those questions as we go. For those of you who are unaware of what the employment law updates are about, is that we've been presenting these updates from about 1980. John Brand, who was a partner with Bowman's, introduced them in 1980. And I started participating in 1985. We've been presenting it on a quarterly basis for many years. It's been done through an organization of John's called Conflict Dynamics, and we did it as a training format on a 4-hour basis. With COVID, we've decided to change the format and rather do it as a webinar presentation, reduce the number of cases we deal with, and do it in a shorter webinar format, as I said. What we try to do is try to keep you updated with developments in the law. What we find is that the courts are constantly developing the law. We thought when we were doing this in the 1980s and 1990s that we would run out of topics, but incredibly, the courts reinterpret the law all the time, develop the law all the time, and we've never ever actually been short of anything to say. What we also try to do is introduce topical issues, stuff that will be relevant to the workplace, things that you may well encounter, problems that you may have to deal with, and we try to make it as practical to you as possible. So we try to avoid technical issues, kind of eliminate issues, the kind of things that lawyers like, and rather make it the kind of things that the participants like. Today, we've got a very full program of 12 or 13 cases that we need to get through. They are very interesting cases, developments in the law, mainly labor appeal court cases that deal with various very topical issues. We're going to cover issues such as strikes, but particularly issues such as strike violence, which unfortunately is part of living in labor relations in South Africa. As we've had very, very violent strikes, and Ros will be touching on that. We're going to touch on retrenchments and particularly selection criteria where you're busy doing a reorganization. We're going to deal with discrimination and the law in relation to that and how it's developing and evolving. And we're going to deal with the kind of typical remedies that are awarded if you lose a dismissal case. We're going to deal with COVID in the workplace, as it's a topical point, and we're getting cases starting to develop in that particular area. And then we're going to end off with a situation where employers can be held personally liable for damages in circumstances where persons may be injured in strike action. So it's a very full program, very topical. What I'll do is introduce each of the speakers as they get through to their topic. I'm going to kick off with Rosalind Davey. So Ros is a partner in the Employment and Benefits practice, has been for many years, has worked alongside me, very competent, capable lawyer. I always feel very safe putting work into her hands. She's a co-author of the book on social media in the workplace, and she's going to talk to you about developments in strike dismissal law, but in particular around the issue of strike violence. So Ros, over to you.
Thanks so much, Graham. Hi, everyone. Welcome to this session. The first case I'm going to be dealing with is AMCU versus the Minister of Employment and Labour. Now, as Graham says, in this country, we've had increasingly violent strikes over the years. This has been a significant problem. And one of the issues that the employers are grappling with is what is the cause of strike violence? Now, there are various causes. One is the fact that there are there's no strike kitty. So employees who are on strike don't get paid. And they resort to violence to try and break the strike earlier. One of the other real issues, which I'm going to be touching on today, is the democracy in strike action. Now, very often what we see happens is the union with select few of its members will decide that enough is enough and they now want to strike. But they don't conduct what we call a strike ballot. Now, this case deals with this whole concept of a strike ballot. Just to give you some history, the Labor Relations Act specifically provides that a union's constitution must provide for the holding of a ballot before a strike is called. Now, in terms of the Labor Relations Act, it says that if no ballot is held, then the union cannot discipline its members who refuse to participate in a strike. So that's the one. The other thing that the Labor Relations Act provides is that if the majority of the union's members do not vote in favor of the strike, then anyone who chooses not to participate in the strike cannot be disciplined. What the Act does not provide, however, is that if there is no strike ballot, you can't strike. And if the majority do not support the strike, you can't strike. So it is very clear that a minority of employees can embark on a strike. What that results in is that employees who don't want to strike and who report for work frustrate the striking employees. And this very often leads to cases of violence, intimidation, blockading, and the like. So in an attempt to start addressing this issue, the Labor Relations Amendment Act introduced a requirement that the constitution of each trade union must provide for a secret ballot. And in the event that there is no provision in the constitution, then there is a 180-day period within which the unions can get their constitution sorted out. And in that period, if they don't conduct a ballot, then the strike is unprotected. Any other strike is not unprotected simply because of the failure to provide a strike, to conduct a ballot. Section 95, I think it is, Section 95, subsection 8 of the Labor Relations Act provides that the minister is empowered to establish guidelines on the conducting of a ballot, and on various other things. And then subsection 9 deals with what constitutes a ballot. Pursuant to the amendments to the LRA and to the problems that have been encountered with strike violence, there were negotiations in NEDLAC where the employers and employee or unions got together to negotiate how to deal with this. And out of this came certain regulations that were published by the Minister of Labour. These regulations provided certain specific requirements that a union must meet when conducting a ballot in order for a strike to be protected. And after the regulations were published, the message from the Department of Labour was that if a union did not comply with these guidelines, then a strike would be unprotected. Now, there was a lot of unhappiness among the unions, with the unions claiming that this was a deliberate attempt to undermine strike action. And ultimately, AMCU approached the High Court, the Gauteng Division of the High Court, to interdict or to set these regulations aside. The basis on which AMCU challenged the regulations were essentially twofold. Firstly, Section 95, subsection 8 empowers the minister to issue guidelines to be applied by the registrar in determining whether a union was a genuine union or an applicant for union was genuine, and then provides for the ballot to be used when going on strike, and that it must be a secret ballot. What the minister did was she provided these guidelines in terms of 95 sub 9, not subsection 8. So AMCU took a technical point to say she was not empowered to issue these guidelines because she used the wrong section firstly. The other argument that AMCU raised was that the power of the minister is limited to providing guidelines. What were actually issued by the union were requirements. And what how the minister had framed it was the trade union must give reasonable notice of a ballot, specify the time and the place of the ballot, etc. And it became a requirement. And then obviously, as I said, the message from the department was, if you don't comply, then your strike is unprotected. You cannot go on strike. What AMCU said is that these are mandatory requirements. They are not guidelines. And for that reason, the minister has exceeded her powers. Now, in court, the ministry tried to explain and say, but these are guidelines. They're not intended to be mandatory. And they are made in terms of section 95.8 read with 95.9. And therefore, the minister was empowered to make them. The Gauteng High Court said no, said if you look at the specific wording of the act, and if you look at the basis on which the minister claimed to be empowered to make these regulations, she didn't do it correctly because she did it in terms of the wrong subsection, and therefore she was not empowered to do it. And then the court looked at the wording, the use of the word must as a requirement for the conducting of a ballot. And the court said that is incorrect. The minister is not empowered to make mandatory or to set mandatory requirements for the conduct of a strike ballot, and that in doing so, the minister has exceeded her powers. And for that reason, the court set aside the regulations. The result of that is that we're now back in a scenario where although there is this requirement to conduct ballots, there is no way for an employer to enforce the requirement. Now, the reason I say that is the Act specifies that the union's constitution must provide for the conducting of a ballot, but it does not require, or it does not result in a strike being unprotected. And this was a way in which we could have possibly minimized strike violence, but unfortunately, because this has now been struck aside or set aside, I think we're still going to face the same difficulty with unions calling for strikes without the support of their members. And that is going to result in frustration among the striking employees when their colleagues attempt to report for work. So quite an important case. It has quite far-reaching obligations, although nothing has, far-reaching results, although nothing has really changed to what the law was beforehand. So the long and the short of it is, if unions don't conduct a strike ballot, they can still strike. The strike is protected, although they will be acting in breach of their constitutions. So that's the first case that I wanted to talk about.
Ros, just stopping you there, but essentially there was a lot of promise that came out of that NEDLAC report that we could eventually try and deal with this violence issue. The one way was by way of balloting, and the other way was by way of trying to limit the conduct of strikers during strike action. And it seems to me that that accord is now worth virtually nothing, if I'm not mistaken. It's almost as nothing's changed pre that situation. We're back to exactly where we were before the accord, and it's not delivered what it was meant to deliver.
Yeah, that is correct. So nothing has changed. I think even the amendments that came about as a result of the Labour Relations Amendment Act don't really help, because there was that 180-day period. It may impact on unions that go. I think there was a case where a union went on strike without having provided for a ballot in its constitution, and that was interdicted, but it was very, very limited in scope. So we still can't interdict strikes for a want of a strike ballot. The citation of the case, I see someone is asking for that. The citation is AMCU versus the Minister of Employment and Labour, It's a 2021 case. It's ZAGPPHC 193. And if you Google it, it'll come up on SAFLI. All right, the next case that I will be dealing with is the case of Pelpak versus De Beers. Oh, De Beers, sorry. So De Beers being referred to here as the commissioner, not the company. It was first mistake I made when reading the case. This case also deals with strikes, but it deals with strike misconduct. What happened in this dispute is that NUMSA called its members on a national strike in the metal and engineering industry. The company in this case, Pelpak, falls within the scope of the bargaining council, and its employees embarked on the strike. During the strike, what happened was the employees employed by Pelpak at their factory in KwaZulu-Natal came into the picket, and they were holding sticks, shamboks, golf clubs in the picket line. Now, Pelpak had introduced a new disciplinary code just prior to the strike. And one of the misconducts described in this disciplinary code was the brandishing of weapons in a picket. And the code said, striking employees may not brandish or wield weapons whilst striking. And the consequence for an employee breaching this rule would be dismissal. In addition to that, Pelpak had issued a picketing policy. Now, at the time that they issued the picketing policy, it had not been signed by the union. But this policy also provided that striking employees may not hold weapons when in the picket. The disciplinary code was placed on a notice board. So there was a notice board in the factory that all employees were required to have regard to. They were required to check what was put on was required to check if they were, if their rosters were on, if there were any rules, if there were any communications. So they were required to check the notice board regularly. So it was placed there when these amended rules were implemented. Then the picketing policy was placed on the walls outside near the gates where the picketers were. So once the policy had been implemented, because the employees were already picketing, this policy was put on the wall for the picketing employees to read. And it was put next to an SMS or a printout of an SMS that the company had issued to its employees, calling on them to return to work. Notwithstanding the policy and the rules, the dismissed employees in this case continued to come to the picket brandishing their sticks and their shamboks. And as a consequence of this, at the end of the strike, these employees were dismissed for misconduct, more specifically for breaching the disciplinary rules and for breaching the picketing policy. The union and the employees approached the CCMA, and they alleged that their dismissal was unfair. Now, they didn't challenge the validity of the rules. So they didn't say that the employer couldn't make such rules, and they didn't even say that the rules were unreasonable. They said, we did not know about the rules. They were not brought to our attention, and therefore we did not commit misconduct. The other thing they said was that they were not brandishing or wielding weapons. They were simply holding sticks. So that was what the arbitrator had to consider. Now, in that case, the arbitrator found that on a balance, she was satisfied that the employees didn't know about the rules. So she seems to have accepted that the rules were put on the notice board, and she seemed to have accepted that the policy was put on the wall. But she said she was not satisfied that the dismissed employees had read the rules and that they had read the picketing policy. And she therefore found that the dismissals were substantively unfair, and she reinstated the employees. The company then took the dispute on review to the Labour Court, and the Labour Court, in considering the dispute, said that it was apparent that the commissioner had considered all the evidence. She had justified the conclusions for her finding, and the court therefore was satisfied that the decision she reached was a reasonable decision or fell within a band of reasonable decisions, and therefore that it was a correct decision, and refused to review and set aside the award. Now, the company was dissatisfied with that, and they approached the Labour Appeal Court. The Labour Appeal Court said that the crux of the dispute was, did the employees know about the rule, or should they have known about the rule? So it's that, were they aware, or ought they reasonably to have been aware of the rule? And that's what the court said, that both the Labour Court and the arbitrator should have considered. And in determining that, the court listened or looked at the evidence of the employees. Now, the evidence of the employees, or the dismissed employees, was that they didn't see the rules on the notice board. But it was very clear from the evidence that they knew that they were required to check the notice board, that the rules had been put on the notice board, and that if they didn't know about the rules, they ought to have known about the rules because they should have checked that notice board. And then with regards to the picketing policy, the employees seemed to accept or admit that they read the printout of the WhatsApp message that was next to the policy. And they said, yeah, but that was there, but they disputed that they read the policy. And one of their explanations was that the security refused to allow them to approach the wall, so they couldn't read it. And the court said, well, that doesn't make sense. You can't, on the one hand, have accepted that you've read the SMS or the printout of the SMS, but then say you couldn't approach the wall where the SMS was attached to read the rules or the policy. So on a balance, the court accepted that the employees knew or reasonably to have known about both the rules and the policy. The next argument that was raised by the union was that, well, even if they did know, which they didn't understand the consequences of that, of a breach, because the picketing policy did not set out what the consequences were. The court said, but that's actually not correct. Firstly, if you have regard to the rules clearly state that dismissal will be considered as appropriate sanction for breach of the rules, specifically for the having weapons in the picket line. And the policy, although it didn't say that dismissal would follow, it did say that employees who breached the picketing policy would face disciplinary action. So the court was satisfied on that basis that they knew or ought reasonably to have known about the consequences of a breach. The final issue for determination then fell on whether or not carrying sticks and shamrocks and golf clubs in the picket constituted brandishing of weapons. And the court said in a lot of the photos, they could see the employees holding the sticks above their heads, and that it was done in an intimidatory way. There was also evidence that some of the security were nervous. They were concerned about the picketers and their own safety. And there was also evidence that suppliers, truck drivers had to be escorted from the premises when going through the picket line. And for that, on that basis, the court said, look, absolutely, this constitutes brandishing of weapons for the purpose of the policy, and ultimately found that the dismissal was appropriate and overturned the arbitration award and substituted with a finding that dismissal was substantively fair. Very important from this case is the need to make sure you have the rules in place. Personally, I think that, or I would have argued that even if there was no rule against brandishing weapons in a policy, employees should know coming to a picket holding a golf club or a shambok is a no-no. That is unacceptable conduct. But I think to be safe, it is better for employers just to ensure that they have those rules in place and that they are clearly articulated. and that they are made available to employees. So there's no obligation on the employer to actually force its employees to read the rules, but they must be in a place where the employees should know that they are required to read them and be aware of them. Okay, anything you want to add?
One of the questions is, if a union has complied with Section 64, in other words, done everything that would protect a strike in those circumstances, is there anything that would render that strike unprotected? For instance, if it became violent for any protracted period of time or anything else that would potentially render it unprotected?
If I'm not mistaken, in terms of the Code of Good Practice that was introduced a couple of years ago, there was a requirement or a statement that a strike that had persistent strike violence would become unprotected. I'm not certain if there's case law that has followed that, but one of the things that a company could look at was whether or not the union was a member of the accord on the collective bargaining. So there was an agreement between union and companies that set out the appropriate conduct for collective bargaining, including strike action and pickets. And one of the undertakings or the agreements there was that the unions and the employers would comply with the Code of Good Practice. So although the Code of Good Practice is a guideline, there was an agreement that they would act in accordance with that. So there may very well be a basis on which to seek to interdict any strike action for violence based on a breach of the accord. I think there was a case, and Graham, just jump in if you remember, I think there was a case where the courts, because they are getting increasingly concerned about strike violence, I think there has been a Labour Court case where a strike was interdicted because of persistent ongoing violence. But I'm not sure if that is the correct position. What I think would be a safer option would be to interdict the picket. And I don't know that you'd be able to stop the strike itself, but there are good grounds to say these guys should not be allowed to picket because of the violence. Another option would be to approach the court to have the picket line moved as far back or as far away from the premises as possible to minimize the violence and the impact.
Thanks, Ros. Talita, so Talita Laubscher is a senior partner in the employment and benefits practice, the author of various publications and an expert on discrimination law, POPI, and a whole variety of various topics in the labor field. I'm going to hand over to her to deal with protest action. So protest action is not strike action directed at an employer. It's protest action directed at the socio-economic policies generally of government. And there is a methodology by which that can be protected. We haven't seen that much protest action lately, but T, you can take us through when and how you can protest.
Thanks, Graham. Good morning, everyone. I'm freezing today. I don't know why, but I hope you're all warm. Yeah, it is interesting that protest action is one of the things that is regulated in the Labour Relations Act. And it is because the workforce is intimately involved in doing these protest actions. Section 77 of the Labour Relations Act is the relevant section, and that section says every employee who is not engaged in an essential service or in a maintenance service has the right to take part in protest action, and then there are certain limitations. The protest action must have been called by a registered trade union or federation of trade unions. The registered trade union or federation should have served a notice on NETLAG stating the reasons for the protest action and the nature of the protest action. Number 3, the matter giving rise to the intended protest action must have been considered at NETLAG or another appropriate body where the parties concerned can actually resolve the issue. And if that doesn't work, at least 14 days before the commencement of the protest action, the registered trade union or federation must then have served a notice on NETLAC of its intention to proceed with the protest action. Interestingly, protest action that complies with these requirements is protected, similar to protected strike action, which means that an employee cannot be dismissed for taking part in such protest action, but also the employee isn't working and therefore the employee isn't entitled to be paid during the period of protest action. The Act further says that it is the Labour Court that has exclusive jurisdiction to determine whether the protest action meets these requirements, and if not, it can interdict the protest action concerned. So this was the section that was relevant to the facts that had their origins way back in 2017. In August, on the 21st of August 2017, COSATU issued a notice to NETLAC, and in that notice it said that it is intending to embark on nationwide protest action, and I want to read to you the reasons why they wanted to embark on protest action. You will recall back in 2017, there were serious retrenchments happening across the country, and the unions took issue with that. It said the current wave of retrenchments is of great concern to society and not only trade unions. One of the consequences of trickle-down economic policies in the labour market is that employers must be allowed to hire and fire workers at any time and for any reason. And this was their big gripe, including for increasing their profits. And it is this labour flexibility that has played a major contribution in the dismissal of workers and increase in poverty. This philosophy is not consistent with Ubuntu, South Africa's socio-economic challenges, and to need to rectify the legacy of apartheid and colonialism. The maintenance of high levels of profits and bonuses to executives cannot be a fair reason for retrenchment. South Africa is facing a job bloodbath. And it went on, and it says it is unacceptable that retrenchments for profit are permitted. It then issued a number of demands in that notice. It said companies are getting generous tax benefits and subsidies, and in consideration for those, companies must be prohibited from retrenching employees for the sake of profits. And instead, they must be required to create a certain number of jobs per year, and this must be monitored by the CCMA. They then also called for the creation and convening of an economic and job summit, and that notice was given to NETLAC. So following that notice, that you will recall that was on the 21st of August. On the 15th of September, NETLAC then convened a meeting at NETLAC. It was its standing committee, and participants included government, labor, and business. The parties couldn't agree there that employers should not be permitted to retrench where the reason is to increase profits, and the matter was unresolved. Then on the 15th of January 2019, so about 18 months afterwards, COSATU issued a notice in terms of section 77(1)(d). And that is, you will recall, the notice in terms of which it gives at least 14 days notice that protest action will take place. So it said, because we couldn't reach consensus and all these things are continuing, we will embark on protest action on the 13th of February 2019. About 2 or 3 weeks later, on the 5th of February, it issued a further notice, also in terms of section 77(1)(d), and said, in addition to the protest action on the 13th of February, we will also protest on the 19th of February. From the Act, it seems that these protest actions took place. At the time, BUSA did nothing to try and stop or prevent that from happening. Then, very interestingly, another 6 months went by, and on the 28th of August 2019, COSATU filed another section 77(1)(d) notice. And it said it is now going to focus specifically on the financial sector, where there has been a lot of retrenchments happening, and it is going to embark on protest action on the 27th of September. The next day, it issued another notice, and it said, in addition to the protest action on the 27th of September, we are also going to protest on the 7th of October. It said it is going to be a 1 day, but there's going to be a week of protest action in meal breaks and so on. So there is going to be activity at workplaces during that week. And then on the 7th of October, there's going to be a national stay away, and then employees are going to protest against all of these retrenchments for profit and the new liberal economic policies. So at this point, BUSA then intervened, and it went to the Labour Court and tried then to interdict the protest action. It said, this is a notice in terms of section 77(1)(d), but there has been no compliance with section 77(1)(a) and B and C. So this particular issue has not been referred to NETLAC and has not been subject to a conciliation or an engagement process, and therefore, by issuing this notice, they are acting prematurely. Because, of course, the previous protest action took place, and now COSATU wants to go out again on the very same basis. The Labour Court agreed with BUSA and interdicted the protest action. It said that that notice should have been issued within a reasonable time period, and that wasn't the case here. And therefore, the protest action was unprotected. COSATU took the matter to the Labour Appeal Court. And at stake here was really this question, was COSATU entitled to call another day or 2 days of protest action on the basis of that initial referral based back in 2017? At the Labour Appeal Court, they argued that the Act actually only requires certain process requirements. There needs to be that notice to NETLAC setting out the reasons for the protest action. There needs to be an engagement with relevant parties, And then notice must be given at least 14 days prior to the protest action, and that is really all that is required. For BUSA, it was argued that this section is located in the LRA, and the LRA requires the expeditious resolution of labor disputes, and it is therefore not right for COSATU to come along and to come and protest on the back of a notice that was issued 2 years before. The Labour Appeal Court considered this, and it said, actually, this is not a labour dispute per se. Protest action enables all citizens and employees to protest against, as Gray mentioned, socio-economic policy issues. So actually, this whole point about expeditious resolution of labor disputes doesn't come into it. Really what we are talking about is, are certain constitutional rights, such as the right to of freedom of association, the right of freedom of expression, the right to assembly, and then also, because we are talking about employees, the right of fair labor practices. The court furthermore noticed that nothing in Section 77 requires that notice in terms of Section 77(1)(d) to be given within a specific time period after your initial period notice was given. And in light of these factors, the court said it didn't matter that a period of 6 months had elapsed and another notice was issued on the very same basis as the initial one that was issued way back in 2017. So it confirmed that those kinds of notices do not become stale. It is important for citizens and employees to be able to protest against socioeconomic policies. They pay a price for doing so because it is the no work, no pay principle applies. And as long as they then comply with those requirements in the Act, that would be in order. Of course, if it is now a completely new demand and a new complaint that comes into it, a fresh notice would be required. But in this case, the court was happy that that wasn't necessary.
Thank you, T. That was, yeah, so essentially you can have what effectively we call a grasshopper strike or grasshopper protest action, where you just keep going out year after year after year on the same initial referral, provided you're giving your 14 days notice. But that's essentially it. It never becomes stale and you can keep going. Thank you very much for that. So we're going to move on now to retrenchments. Very often with retrenchments, it's not simply about cutting back on numbers of employees where you say, I don't need so many employees. Very often what employers do is reorganize a business to work differently. They take out structures, they take out layers of management, and in those circumstances, issues around selection criteria often become relevant, and you hear employees complaining that I'm being made to apply for my own job, things like that. So to talk about it is Lasanda Rapula. Lasanda is the head of our employment and benefits practice. She's been practicing for many years, acted as a judge on a number of occasions. So over to you, Lou. Thank you.
Thank you, Graham. Good morning, everyone. The retrenchment case I'll be dealing with this morning is Telkom SA Limited versus Van Staden and others. It's a Labour Appeal Court case. The facts of this matter are central to the case, and the central question really for this morning's purposes is in relation to the process around restructuring and selection processes. So what happened in this matter is that in 2014, Telkom embarked on what it called a Fit for the Future business restructuring exercise. And the rationale by Telkom for this restructuring Fit for the Future involved various factors, one of which was improving profitability. The second was securing financial stability by reducing human capital costs at the management levels and specialist levels specifically, and also flattering organizational hierarchy so that it was flatter and there were less levels between the various managerial employees. It was anticipated that looking at a total of approximately 20,000 employees at the time, 19,215, that 2,635 managerial employees would potentially be affected by this proposed restructuring exercise. There were various selection criteria that were put forward by Telkom. These included qualifications and experience, what they called the best fits for the job, qualification and potential, what they called future business requirements to execute strategy, LIFO, last in, first out, that LIFO would be used where there was more than one employee that qualified for appointment into the same position, employment equity retention, and also leadership potential. It was stated that if after using the selection criteria and the different levels, an employee was not able to be placed, that employee would be put forward for retrenchment. A position was deemed to be affected if the job functions changed, and the employees were then allowed to apply for roles either at the same level that they were at, one level above, or one level lower. In order to do this, a placement panel was put in place by Telkom, and this placement panel would consider suitability of employees. Employees were initially allowed to apply for 3 roles, and suitability for their top 3 roles would first be considered by this placement panel. In addition to the placement panel, there was also an assurance panel. And the role of the assurance panel was to ensure that the given selection criteria were applied by the placement panel. Consultations were held with the trade unions, even though there were unionized employees as well as non-unionized employees. But given the large number of employees that needed to be consulted with in the exercise, and given the fact that they were placed in different geographical areas, it was decided by Telkom that consultations would be with the 4 trade unions. In addition, there were various road shows in the different towns where employees were placed at. And in addition to the road shows, there was an intranet portal that was put in place. And on this intranet portal, Telkom placed all the questions and answers that had been dealt with the trade unions. And in addition to that, the non-unionized employees could use this intranet portal for them to engage with Telkom. The process was separated in 3 phases. In relation to the first phase, employees were considered for roles. They were not interviewed for the roles, but their submissions in their applications for the role and their motivation for the role were considered by the panel in phase 1. And the panel was made up of 3 senior management, a representative from human resources, as well as a representative from line management. If an employee was not placed at the end of stage 1 and they were unhappy with the fact that they had not been placed, they were able to raise an objection, and this objection was provided to the chairperson of the placement panel as well as to the employee's line manager. And then those 2 people, the chairperson of the placement panel and the employee's line manager, then gave the employee the reasons for why they had not been placed. If the employee was still unhappy, they could appeal. And the appeal process was chaired by an external human resources consultancy. The appeal decision was final. Then there was a second stage. In terms of the second stage, affected employees were considered for placement for positions that were outside of the top 3, but that were still vacant. They were then considered for these positions. There was no formal process for objection and appeal as there was in phase 1. So in phase 2, you were just considered, and if you were not placed, you're not placed, you couldn't then object. If you're not placed in phase 2, the final phase was phase 3. And this phase 3 was termed business as usual. In terms of phase 3, infected employees could apply for placement into any vacant posts. But in phase 3, the vacant posts were not secured for potentially affected employees. All other employees of Telkom who were interested in these vacant posts could also apply. And over and above that, external applicants could also apply for these vacant posts. Throughout the exercise, Telkom received several applications from employees for severance packages and also for voluntary early retirement. Now, the employees in question in these proceedings, the 10 employees, sued Telkom in relation to the retrenchment exercise for various reasons. The first was that they disputed the operational requirement as a whole. They said that Telkom actually didn't have a need to reduce losses or increase profits because actually surplus funds had been spent on lower level employees, and also that there were still approximately 2,000 contract workers, and also that an amount of approximately 4 million rand had been spent by Telkom for the refurbishment of a gym. The second reason that they objected to the validity of the retrenchment exercise is that they disputed that the selection criteria were fair and objective. They said that consensus had actually not been reached on the selection criteria and that employees had in fact been identified for retrenchment before the consultations had actually commenced. Thirdly, the employees claimed that the consultations were not meaningful or exhaustive and that themselves specifically not being trade union members, their suggestions and proposals for potentially avoiding retrenchments had not been considered at all. The fourth element was that the employees said further, since Telkom had actually, through the voluntary packages and the voluntary retirement that some people had taken up, that exceeded their target to reduce managerial staff by 223 employees. And therefore they took issue with the decision to retrench a further 105 managerial staff when there were 169 vacancies that remained available. Now we look at what the Labour Appeal Court said on all these various issues. On the operational requirement, the Labour Appeal Court said, unfortunately, evidence had gone unchallenged at the Labour Court as to Telkom's need to restructure. It had gone uncontested at the trial, and therefore it would not be second guessing the operational requirement as the Labour Appeal Court. It would not be going into that at all because it had actually been gone, it had gone uncontested at the trial at the Labour Court. On the consultation process, the court held that the Labour Court didn't find that the lack of individual consultation was problematic. It said that the trade unions had been extensively consulted over a number of months and that there was actually no legal obligation to consult employees individually. A central issue rested on whether the Labour Court was correct in finding that the selection criteria were unfair and or unfairly applied. And the Labour Appeal Court then looked specifically at this issue of the selection criteria in the restructuring and the flattening of the managerial levels. The court held that there's nothing innately unfair in requiring an employee whose job is affected to apply for a position in the restructured operation. It held that if the placement process was unfair because it was subjective or if it was arbitrary or because it was inconsistent, then that would taint the fairness and ultimately the decision to dismiss. But it held that in this case and in these circumstances, the selection criteria were not necessarily the subject of agreement And therefore, since they were not necessarily the subjects of unanimous agreement, the selection criteria had to be fair and objective. It was important that the selection criteria were in any event fair and objective. It held that the placement process applied across the board to all affected employees, and that the process was actually fair, it was extensive, it allowed for employees to object, it allowed for them to be given reasons for when they were not placed, and therefore it held that there was nothing per se unfair in the process that was undertaken by Telkom. Ultimately, therefore, the Labour Appeal Court held that the litigating employees had not shown that they were unfairly selected for possible retrenchment, and it held that their dismissals were not unfair. And in conclusion, therefore, it held that the dismissals were both procedurally fair and substantively fair.
Thanks, Lou. Yeah, I mean, I must say, in terms of selection processes and procedures, I don't think I've ever seen a more detailed one in my life, where there are rights of appeal, rights to reason, rights to go external. I think you can hardly fault one like that. But it does raise this very interesting issue of where people you are displaced because you abolish their jobs, but then they are required to apply for different positions within the organization, and how you go about selecting them for those positions, because clearly the selection criteria for those retrenched are those who don't meet the criteria for being placed in a position. So you're displaced because you don't meet a criteria, which is always an interesting way to look at it. But thank you very much for that. We're going to move on to the unfair discrimination case and the issue of when you can use employment equity considerations to deny somebody a vacant position. And T, as the expert on unfair discrimination, I'm going to hand over to you. Thank you.
Thank you. Yes, I must say I am very grateful for this case. It is Naderson. Let me just get you the right citation here. Yeah, eThekwini Municipality. And Mr. Jorga Naderson, also the CCMA, and the commissioner was Mr. Pillemer. This is a very useful case because it gives us practical guidelines as to when an affirmative action measure in a plan would be regarded as a valid defense to the non-appointment of someone. Mr. Naderson applied for the position of a senior storekeeper in the Fire and Emergency Services Department of the eThekwini municipality. The evidence was that this was a very important position because essentially this person is responsible for ensuring that the correct firefighting equipment is ordered, is there, and can be issued to firefighters when they need it. They say it requires in-depth knowledge of specialized firefighting equipment and uniforms, and you don't just learn that. You can only get to that knowledge through a gradual experience working your way up from the position of the storekeeper. So he would be the senior storekeeper. He has been, well, at the time he had been a storekeeper for many years, 15 years experience, and he then applied for this position that was advertised. The selection panel recommended him for the job. They said, yes, they had a look at the employment equity plan of the municipality and the targets that were set out there. In terms of that, the demographics at the time, the race and gender representativity reflected that Indian males were oversubscribed by 505, Indian females by 108. And remember, this is eThekwini, so that probably makes sense. African males were oversubscribed by 1,038. White males were undersubscribed by 253 and white females by 211. And African females, that was really their big challenge. They were undersubscribed by 1,411. So there were too many Indian males, too many Indian females, too many African males. And because of that, the person that needed to sign off on Mr. Naderson's appointment declined to appoint him, Mr. Mchunu. And he said, we need to re-interview and we must look for suitable candidates. Because he was rejected, Mr. Naderson then took the matter to the CCMA, and the CCMA held that that rejection constituted an act of unfair discrimination because he was denied appointment solely because of his race. At the Labour Court, the court said, all right, let's look at this carefully. Under Section 6(2) of the Employment Equity Act, an employer is permitted to say, I am preferring someone on the basis of race if this is in accordance with an affirmative action and employment equity plan as contemplated in the Employment Equity Act. So now what is important is to work out whether this action of refusing Mr. Naderson was actually a permitted affirmative action measure in these circumstances. Mr. Naderson scored by far the highest in the recruitment process. There was a difference of 40 to 50% between him and the very next candidate. And it was common cause that he was denied because of the fact that he is an Indian male. The court said often when these kinds of issues are determined, one looks at it through the lens of the Constitution, but one needs to be careful there. One cannot, where there is legislation that gives effect to a constitutional right, rely directly on the Constitution. You need to look at it through the prism of the enabling legislation, which in this case is the Employment Equity Act. And the purpose of affirmative action measures as set out in the Employment Equity Act is to ensure that suitably qualified people, well, employees, candidates from designated groups are equitably represented in the workforce of the employer. One must also look at the impact on all other parties. It is not just a numbers game that we are dealing with when we are talking about employment equity. And the court then said there are two schools of thought here. The one school of thought is an affirmative action measure is in order and can be regarded as a defense to an unfair discrimination claim as long as it is rational only. So if we meet the rationality test, which is a fairly low hurdle to get over because it just needs to make rational sense, then that is a defense. The other school of thought is that you need rationality plus fairness. So when you are talking about fairness, you are talking about proportionality of the measure that you are applying to achieve the particular outcome. You cannot use a measure like that in order to achieve a purpose like that. There needs to be a balance between the two. Also, there are other requirements in the Employment Equity Act that you need to comply with. For example, you may not use quotas. You must look very carefully at the percentage that you base your targets on. Is that permissible? You will remember the correctional services case where the targets were set with reference to the national geographic of all South Africans. And there's nothing to support that in the Employment Equity Act. The Employment Equity Act talks of the economically active population, either national or provincial, whichever is relevant. So there are all these internal requirements that need to be taken into account. The court then also considered whether Mr. Nadesan actually had to set aside the employment equity plan of the municipality itself before he can bring this claim. And it said that that was not necessary. And the court went into great detail in relation to what was said in that Barnard decision. You will remember that constitutional court decision where Ms. Barnard was denied a post and the post was re-advertised. And ultimately the court said, you know, actually what she needed to do was to attack the validity of the employment equity plan. And Judge Witcher in this case carefully looked at what did the Constitutional Court majority say and what did the minority say. And very importantly, the majority said the measures need to be rational, but it left open the question as to what other factors need to be taken into account. And it in fact said that there can be other factors that also must be taken into account in order to assess the fairness of an affirmative action defense. The minority in Barnard went further, and the minority specifically endorsed the fact that the measure needs to be rational and the measure needs to be fair. And therefore, Witcher said she is then entitled to say that this is the test, rationality plus fairness, not just rationality. And then what is so nice about this, this case is that she actually gave practical examples of when something would be rational, when a measure would be rational and when it would be fair. And I'm going to take you through those because it is really so useful. So she says, the first thing is, can this measure logically address the problem of the demographic imbalance? In this case, they want to re-advertise the post. In the evidence, under cross-examination, Mr. Mchunu was asked, so do you have African female or white male store, what are they called, storekeepers? In other words, is there a pipeline of people who would enhance the representativity according to your targets coming through the ranks, who could potentially have the potential to perform the work at this level? The answer was no. So the court said in this case, you know, the very first thing that you need to consider is there a logical chance of the measure that you are now applying, which in this case is re-advertising, of actually addressing that problem? And actually it's no, because there's no one that could potentially come and fill this role. The second one is there actually a plan in place? In previous cases, these appointments were struck down because at the time, when that appointment was made, there was no plan in force. And if you are making a decision based on race, it needs to be supported by a valid plan and valid targets and goals. It cannot just be a thumbsuck at the time. So if there is no plan in place, that is going to be a problem from a rationality perspective. Does the plan impose quotas? If it does, that is irrational. It is not in compliance with the Employment Equity Act. What that really means, and we saw that in the correctional services case as well, is that the employer may rely on race to make an appointment decision, but there needs to be room in the employment equity plan for the employer to appoint someone from a group that is already overrepresentative, if that is necessary for proper service delivery, and the post needs to be filled, and those kinds of circumstances. So if there is a quota, it's going to mean that the job, well, that the post must remain vacant until we find someone from a group that will enhance our representativity targets. And the court said that that is a problem, because that is then a quota. So if the demographic statistics upon which your measure is based are wrong, also then it will be irrational. So that again was correctional services. If they based their statistics on the national demographics of the country, not the economically active population, and that was accordingly not in accordance with the Act, and that was wrong. If the demographic targets have already been met, then you can't rely on those targets to support a decision based on race or gender, and that would then be a ground for irrationality. And then lastly, if the employee was not in fact of the particular group that you thought that person was, but also from another other group, then you have a problem. So she says here, if the person was not in fact Indian but an African female, or was Indian but also a member of another equally underrepresented group, then not appointing that person may be irrational. So those are the typical things that would make a measure irrational. And then she goes on to talk about fairness. And she says, there you look at the impact on the individual complainant and the complainant's place in society, but also things like service delivery, the importance of filling the role in order to ensure service delivery. And that assessment is done on a case-by-case basis. So there you look at the realistic prospects of finding a suitable candidate, which in this case was questionable. The number of times that the individual has been considered for the role. In Barnard, she applied twice or 3 times. In this case, Mr. Nadesan only applied once. So she said, yes, he was hurt by the fact that he was rejected based solely on his race, but one must also have a little bit of a thick skin, so that wouldn't have weighed too heavy on her mind. The extent of the underrepresentativity may be relevant here. If there's only 1% of underrepresentativity, the unfairness would be felt very badly by the person that is rejected. But if the underrepresentativity is of a much larger percentage, that might impact on the fairness assessment. And then also the extent of the relative scoring. In this case, Mr. Nadesan scored 40 to 50% higher than the second consideration, candidate for consideration. Also, we must remember that these are targets and not quotas. You also look then at the individual experience of the person that is now rejected. The fact that the individual had acted in that position for a long time and is now rejected, that person's subjective experience through this process, and then importantly, service delivery and the actual operational need to fill that role. And considering these factors, the court said it needs to fail on the basis that the measure that was applied, which was keep the position vacant and re-advertise in circumstances where there isn't a pipeline of potential suitably qualified candidates, that was irrational. There was reference made also in the evidence to articles relating to the emergency services department of the municipality that said that these posts remain vacant for long times and that seriously affects service delivery. And that also the court took into consideration here. So the court held that in fact there was unfair discrimination, and the appeal from the CCMA was set aside.
Keith, thank you for taking us through what is obviously a minefield of law with this in a way that we can understand it. So I do appreciate it. Thank you very much. But an important case for those trying to navigate this particular field, because I think it's incredibly useful how the judge set out all of the law, the various approaches, and did it in a way that we can actually practically apply. But we need to move on. Our next presenter is Ayanda Nkabindi. Ayanda is an up-and-coming associate in our department. He's going to talk to you about COVID in the workplace and dealing with COVID. Thank you.
Morning, everybody. I echo Talita's hope that you're all having a warm winter's morning, because I certainly am not. The case with which I am dealing is Escort Limited versus Damant Mokhotsi. It's quite an important case because it deals with, I suppose, the perils of having employees who have a lackadaisical attitude toward COVID-19 and how it may affect the workplace. So I will begin with what I think are quite a horrifying set of facts, and hopefully by the end you agree with me. But basically, Mr. Mokhotsi was an assistant manager at Escort Limited, which is a butchery business who sell on a national scale. And in July or last year, he used to travel to work with one of his colleagues. And early in July, both he and his colleague started to exhibit COVID symptoms. So as one does, they both went to the doctor. Mr. Mokhotsi went to a traditional healer who in fact was his wife, and she booked him off for a few days. And his travel mate had also gone to a separate doctor and was booked off on sick leave for a few days. Although on about the 6th of July, the symptoms for his travel mate had been exacerbated and he was hospitalized. Mr. Mokhotsi returned to work shortly afterwards, maybe 4 or 5 days afterwards, and he continued to work until about the 9th of August. Now, during that period, on the 20th of July, Mr. Mokhotsi's colleague with whom he traveled to work received a positive COVID-19 diagnosis. And Mr. Mokhotsi, despite exhibiting symptoms and, feeling sick and, the dreaded chest pains and niggle in the throat, he decided that, he could still go to work. And he only decided that on the 5th of August, some 15 or 16 days later, that he would get a COVID test. Now, despite going for a test, he continued to go to work the following days, so the 6th, the 7th, the 8th, and the 9th of August. On the 9th of August, he received an SMS confirming his positive COVID diagnosis. And still on that day, and indeed the day after, he went to work. Now, on the 10th of August, which was the day after he received his positive test, he went to work, and he began the day by greeting one of his fellow employees with a hug. And he went onto the shop floor without a mask, kind of, living in, I guess, what we hope the post-COVID era might look like. And eventually, after he had greeted his colleagues and, gotten up to his shenanigans, he then decided, okay, I will go to my employer and tell them, hey, by the way, I do have COVID. And he did so. And the employer was then like, okay, listen, you've got to go self-isolate. And now, I guess this is a fairly important detail. Mr. Mokhotsi was a member of the coronavirus site committee at the employer. So that means, to an extent, he was he was one of the employees who were there to raise awareness for COVID and also to enforce compliance with COVID protocols and things like that. And so they send him to self-isolate for 2 weeks. And of course, when he gets back, they decide, well, listen, we're going to charge you with gross misconduct and gross negligence. He was charged with gross misconduct because he had failed to inform the employer that he had gone for a COVID test. And gross negligence, of course, because the day after getting his positive result, he, went and hugged and walked around maskless and things like that. And of course, he was sent to a disciplinary hearing, and the employer subsequently dismissed him. Mr. Mokhotsi then goes to the CCMA, having referred an unfair dismissal dispute. And, with all of these facts, which, by the way, are common cause, the commissioner found that Mr. Mokhotsi was indeed guilty of gross negligence. He was grossly negligent. However, the commissioner found that that did not warrant a sanction of dismissal. And the commissioner made this finding on the basis that the disciplinary code of the employer did not indicate that flouting the COVID policies warranted a sanction of dismissal. Instead, on a reading of the disciplinary code, the commissioner found that instead a sanction of a final written warning would have been, or rather was the most suitable sanction. And accordingly, the commissioner awarded reinstatement with back pay. Now, aggrieved by this decision, the employer then took the award on review. And having taken the award on review, the Labour Court pretty much found what I think we would all expect it to find. The Labour Court found that the commissioner's award was not one that a reasonable decision maker would come to, which of course is the well-established review test. And in making this finding, the Labour Court was quite scathing of the employer's conduct. So they pointed out the importance of the rule, and of course, these COVID policies and these rules are aimed at curbing the spread of the pandemic. It's also to protect employees as well as customers, particularly when you're dealing with the butchery, people who handle food and sell it to customers. So, I mean, this conduct, not only in the workplace, but I guess in the context of what COVID demands, was egregious and extremely serious. And the Labour Court pointed this out. And also, obviously, the important thing here was that this wasn't just, an ordinary employee who could plead ignorance about COVID. He was a member of the coronavirus site committee. So the court found, of course, that dismissal was an appropriate sanction. And the court did correct the CCMA by stating that the disciplinary codes are just a guideline. And as long as the correct justification exists, which it did in this case, the employer is indeed empowered to deviate from the disciplinary code. So it's a horrifying case, especially if you are a hypochondriac like me. But I think perhaps one of the more important things is the fact that the employer did not escape this application unscathed, because the court dedicated quite a bit of time commenting on the fact that although the employer does have all of these policies, it's simply unacceptable that Mr. Mokgotsi was allowed in the first place to walk around without his mask, and that he was able to hug other employees, and that employees were hugging each other. Because, I guess we would hope a hug is a two-way thing. Overall, the court found that that dismissal was an appropriate sanction. The award was reviewed and set aside. And hopefully everybody with whom Mr. Mokgotsi did come into contact for that long period of time is okay. And hopefully we never see anything like that again. But that's me.
Thank you, Ayanda. COVID in the workplace is a whole topic all on its own. We could spend hours on it, and whether you can require people to be vaccinated, not vaccinated, but unfortunately we don't have time for that. We've got a lot of program to get through. So I'm going to move immediately on to Zawadi Dlamini, an up-and-coming associate and bodybuilder in our practice. And I'm going to hand over to him and let him present on another dismissal case. Thanks.
Thank you, Graham, for that very flattering introduction. I hope I can do it justice. I think before I start, I want to pose a question to everybody, and hopefully at the end of this, we can answer the question together, right? And that question is this: what happens when an employee is dismissed, right? And they refer their dismissal to the CCMA, and it remains unresolved as conciliation. And then the employee thereafter directly refers the matter to the labor court. And at the labor court, it turns out that the matter should actually have been arbitrated. Can the labor court, in the interest of equity and expediency, hear the matter, or must it be referred for arbitration? And in essence, the case of Nkokeli v. Bloomberg answered this question. In short, the employee was employed as a senior reporter, and during the course of their employment, they had referred an internal grievance against the managers, and after investigation, the grievance was dismissed by the employer. And on a separate occasion, the employee then referred an unfair labor practice to the CCMA, which was also dismissed by the CCMA. Now, sometime after that, on a separate occasion as well, the employer instituted disciplinary proceedings against the employee relating to misconduct which they committed prior to the referral of the unfair labor practice to the CCMA. And following from this misconduct, the employee was dismissed. Naturally, aggrieved by the dismissal, right, the employee referred the matter to the CCMA, which remained unresolved. And interestingly enough, he directly referred the matter to the labor court and argued that his dismissal was automatically unfair as it fell within section 187, subsection 1, subsection D of the Labor Relations Act. Essentially, this section provides that if an employee is dismissed, if the reason for the dismissal of the employee is because the employee took action against the employer for a right conferred to them in terms of the Labor Relations Act, that dismissal is automatically unfair. So in short, right, what the employee is arguing, he's saying that because he lodged an internal grievance against the employer and referred an unfair labor practice to the CCMA, that essentially was the reason of his dismissal. And these two things are rights conferred to him in terms of the Labor Relations Act. Now, the employer also pleaded in the alternative and said, well, look, even if the court doesn't find that it is an automatically unfair dismissal, the court should, in terms of section 1582 of the Labor Relations Act, still hear the matter. Now, section 1582 says, if a matter is referred to the labor court, right, and during the proceedings, it turns out that the matter should have actually been arbitrated, the labor court can actually still hear the matter. And this is essentially what the employee requested the court to do. Now, relating to whether there's an automatically unfair dismissal, the court looked at the reasons or the alleged reasons for the dismissal. So as I said, the first alleged reason was that he lodged an internal grievance, right, against his managers. And the second reason is that he referred an unfair labor practice to the CCMA. And for this to constitute an automatically unfair dismissal, both these two things have to be rights conferred to the employee by the Labor Relations Act. Now, in terms of whether the right to lodge an internal grievance is a right conferred by the Labor Relations Act, the court, interestingly enough, said that this was not a right actually conferred by the LRA. In fact, it's a right conferred to an employee in terms of an employer's internal policy. So if an employer dismissed an employee because they lodged an internal grievance, that would not constitute an automatically unfair dismissal. So in addition to that, the court was also satisfied that the true reason of the employee's dismissal was not that he lodged an internal grievance procedure, or internal grievance rather. So that sorts out the first reason. Now, regarding the second reason, which is the referral to the CCMA of the unfair labor practice, the court said that, strictly speaking, right, the right to refer an unfair labor practice to the CCMA is a right that is conferred to an employee in terms of the Labor Relations Act. So strictly speaking, right, if an employee is dismissed because they referred an unfair labor practice to the CCMA, this would be an automatically unfair dismissal. However, the inquiry doesn't end there, because the court still needs to find out what was the real reason, what was the genuine reason of the dismissal. Was it because the employee referred the unfair labor practice to the CCMA, or was it another reason? And in determining this, right, the court looked at factual causation and legal causation. So from a factual causation point of view, the question that the court asked was, would the employee still have been dismissed even if he didn't refer the matter or the unfair labor practice to the CCMA? And from a legal causation point of view, the question that we ask ourselves is the referral of the unfair labor practice the proximate cause, or is it the genuine cause of the dismissal? And on both counts, the court held that the referral was not the cause of the dismissal. It wasn't the reason of the dismissal. And this is because the employee would still have been dismissed even if he didn't refer the unfair labor practice. And because the misconduct which he committed and he was subsequently dismissed of occurred before the referral, the proximate cause could never be the referral itself. So the court found that there is no automatic unfair dismissal in this case. Now, the interesting question, right, that the court is faced with now is, there is no automatically unfair dismissal, but can it still hear this matter in terms of section 158, subsection 2 of the LRA? And as I said, just to rephrase again and remind you, that section says that if the matter is referred to the labor court and it turns out that it should have actually been arbitrated, the court can still hear that matter if it is in the interest of expediency. In answering this question, the court said, Section 1582 should not be read to confer jurisdiction on the Labour Court in circumstances where jurisdiction does not exist in the first place. Section 1582 is only relevant where the Labour Court already assumes jurisdiction and the matter can also be arbitrated. So for an example, if an employee referred an unfair dismissal to the Labour Court for operational requirements, but at the Labour Court, it turned out that there was an agreement between the parties for the matter to be arbitrated. In that case, the matter can either be referred for arbitration in line with the party's original intention, or if expediency dictates, the Labour Court can hear that matter itself. The court highlighted very importantly and said, Section 1582 should not be read to confer jurisdiction on a court in circumstances where it doesn't have jurisdiction, because if it is read like that, it will lead to an abuse of process, and litigants will rely on this section and circumvent the LRA and circumvent the requirement for arbitration and confer jurisdiction to the Labour Court. So in conclusion, the two important things we can take away from this case is this. Number one, the right to lodge an internal grievance is not a right conferred by the Labour Relations Act. In fact, it is a right conferred by an employer's internal policies. And if an employee is dismissed because of this, it is not an automatically unfair dismissal. And secondly, Section 1582 of the LRA does not confer jurisdiction on a Labour Court in circumstances it does not have jurisdiction. So in our example, if there is no automatically unfair dismissal, the court cannot hear the matter and the merits of the matter and cannot determine whether the dismissal was fair or not. This has to be arbitrated by the parties.
So Wadi, thank you very much. I'm going to move on quickly because we've got limited time. I'm going to move on to Melissa, again, up-and-coming associate in our virtual Cape Town office, just to deal with another dismissal case. And then I'm going to rearrange the program a bit just to get through some of the most important cases like the Churchill case. So Melissa, over to you. Thank you.
Thanks very much, Graham. I'm going to try and keep it short and sweet. I'm going to be discussing SABC versus Pasha. It's a 2021 decision of the Labour Appeal Court. And it's one of those cases which illustrates the very frustrating attempts of employees facing disciplinary proceedings and raising numerous in limine points or technical points in order to delay the proceedings. And it's also a case that focuses on an employment contract, which includes in its clause the requirement to hold a disciplinary process or to comply with the disciplinary procedure. And this case illustrates why those kinds of clauses can cause problems for an employer when an employee has committed misconduct. So in this case, the general manager for commercial services was charged with gross misconduct. And the parties had agreed to conduct a pre-dismissal arbitration as contemplated in section 188 capital A of the LRA. And that's where an arbitrator at the CCMA is appointed to arbitrate the dismissal. Now, the first commissioner that was appointed, Ms. Pasha, took issue with, and she indicated that this commissioner had acted for SABC in a number of other disciplinary proceedings. And she alluded to some form of collusion between the SABC and this particular commissioner. She mentioned that this commissioner had often conducted the disciplinary inquiries at the SABC's attorneys of record at the time, which was Worksman's. And so she made an application for recusal, which was accepted. Then another commissioner was appointed to arbitrate the pre-dismissal dispute. And Ms. Pasha recognized this commissioner as being the same commissioner that had dismissed Mr. Claudi Motsoeneng, who was obviously the previous CEO of the SABC. And she made similar allegations that there was bias and potentially a lack of impartiality if he were to continue with these proceedings. So she brought another application for recusal. That application for recusal was dismissed, but prior to it being dismissed, the company was very frustrated by the conduct of Ms. Pasha. And they were also taken aback by the allegations that she had made against the SABC relating to collusion and bias with these particular commissioners. And they considered this to be a further and separate act of misconduct. So they issued her with a letter, purportedly in terms of a term in her employment contract, which permitted either party to terminate the employment agreement with or without notice. And they said that her conduct was a separate and discrete act of misconduct, which would justify summary dismissal. And they gave her an opportunity to give reasons as to why they shouldn't summarily terminate her employment. Now, this was separate to the Section 188A proceedings that were already underway. Ms. Pasha obviously responded and said, you're not permitted to do that in terms of my contract of employment. My contract of employment indicates that if there's serious misconduct, you must comply with the disciplinary policy and you must hold a disciplinary process. And in addition to that, there's already the Section 188A proceedings that are already underway, and those must be completed. Notwithstanding those submissions, the SABC continued to dismiss her. They terminated her contract, relying on the summary termination provision of her employment contract. Then Ms. Pasha referred a dispute to the Labour Court in terms of Section 77 of the BCEA, which is a dispute relating to an employment contract. And she indicated that the termination was unlawful because they did not comply with the provisions of the employment contract, and that she ought to be put back into the previous position that she was prior to the termination. The Labour Appeal Court agreed with Ms. Pasha. They indicated that there was a requirement to conduct a pre-arbitration or pre-dismissal hearing prior to terminating her. And in this instance, the court focused on the fact that the misconduct in question, which was the conduct of the employee in relation to her recusal applications, was intricately linked to the proceedings that were already underway. So it couldn't be treated by the employer as a separate and discrete act of misconduct, which in the ordinary course could result in separate proceedings being initiated. And it also prevented the company from relying on the summary termination clause. In that case, the court found that the company's conduct was unlawful, and they did put Ms. Pasha back into the position that she was prior to the termination. So in that case, the company was required to continue with the Section 188A proceedings. And the court also mentioned that it was possible in those circumstances, rather than to try and create a parallel misconduct process, to simply incorporate the new allegations of misconduct into the Section 188A capital proceedings that were already underway. It wasn't necessary to indicate that this was a completely separate and discrete act of misconduct. So this case illustrates the importance of looking at your employment contracts and considering where does it refer to the disciplinary code? Does it refer to the disciplinary code merely as a guideline? You know, ordinarily we require employees to just know and be aware of what the disciplinary guidelines are, but that the employer amends it from time to time. It's a guideline. It shouldn't be something that is incorporated as a term of an employee's contract, because if an employer deviates from that, then you're potentially facing breach of contract provisions and enforcement in the Labour Court under those circumstances. And also in this case, you know, as frustrating as it was that the employee raised these eliminate proceedings and delayed the process, the recusal applications were dismissed. So once they were dismissed, the employer could have continued with the proceedings and incorporated the new allegations of misconduct in those proceedings. So hopefully that's short and sweet enough.
Thank you, Melissa. I really appreciate it. I'm going to move straight on to discretionary benefits, and I'm going to introduce Lenya. Lenya is my right-hand person, co-author of the book on workplace, social media in the workplace. And we have very often to deal with where employers have a discretionary right to exercise in relation to whether they grant a benefit, a bonus, or don't grant a bonus. And there are limitations in relation to that. So Lenny's just going to talk you through that.
Thanks, Graham. Being his right-hand person, I can read the subtleties of his facial expressions, which is telling me to keep this very short and sweet for fear of punishment after this presentation. So I'm going to take you very, very quickly through the principles. So this matter of Skinner and 200 others versus NAMPAC concerned a challenge to NAMPAC's decision to cap its contribution to eligible employees' post-retirement medical aid benefits on the basis that it amounted to a breach of contract or an unfair labor practice. So before I briefly get into the facts of this matter, I just want to set out the law insofar as it pertains to contractual rights and the exercise of a contractual discretion. So as you'll all be aware, where a contractual right exists, the right cannot be changed or done away with unless there is express consent from the affected party. So for example, where a contract of employment provides that an employee will work in a particular position, any change to his or her position would need to be agreed upon with the employee. The existence of a contractual discretion is different. And what I mean by this is that the contractual discretion clauses are those clauses in an employment contract or a policy which reserve an employer's right to make amendments to a policy or procedure in its sole and absolute discretion from time to time. So that's why it's known as a contractual discretion, is because it reserves the employer's discretion contractually. In circumstances where a contractual discretion is exercised, an employer doesn't need to obtain the consent of an employee to the proposed change. But this doesn't mean that the discretion is completely unconstrained. The law on the exercise of discretion provides that an employer is required to exercise its discretion fairly and reasonably. And this obligation arises from the common law duty where both parties, the employee and the employer, owe a duty of good faith to each other. And what this means is that neither party can behave in a way that might destroy or seriously damage the relationship of trust and confidence between them. The duty of good faith has also been bolstered by the unfair labor practice provisions in Section 186 of the Labor Relations Act, particularly insofar as unfair conduct in relation to the provision of a benefit is concerned. The Labour Court has confirmed that the unfair labor practice definition also applies to those benefits where an employer enjoys a contractual discretion, namely that the discretion needs to be exercised fairly and reasonably. So in considering whether or not a contractual discretion has been exercised fairly and reasonably, the courts will analyze both the substance of the decision. So what is the reason for making the decision? And also the procedure that was followed by the employer in implementing the decision. So even though you don't have to get the employee's express consent, you still need to follow a notice and comment procedure. So basically tell them why you're thinking of doing what you're doing, get them to make representations, and then ultimately on the basis of those, either implement or not implement the decision. So now that you have those background principles, I'll just quickly get into the facts of the Skinner matter. So in this matter, NAMPAC had historically made provision for post-retirement medical aid benefits for certain qualifying employees. The employees' contracts of employment confirmed that they qualified for the medical aid benefits in terms of NAMPAC's medical aid policy. So while the contract referred to the policy, the actual substance of their entitlements was given content in the policy. All of the applicants in this matter, so about 210 of them, were all eligible for post-retirement medical aid benefits in terms of the policy. The policy provided that members would be eligible for post-retirement medical aid if they met certain conditions. And depending on whether or not these conditions had been met, the company would either subsidize 50% or 100% of their post-retirement medical aid subscriptions. In terms of the policy, all of the employees' membership or post-retirement medical aid entitlements was made expressly subject to a provision in the clause which said that the company could, at its own discretion, in respect of future pensioners, set a cap at which it was prepared to subsidize their post-retirement medical aid membership. And in such an instance, the pensioners would be responsible for the balance between the cap and what was the actual medical aid membership. So over the years, NAMPAC's post-retirement medical aid liability increased significantly, largely due to medical aid inflation. And this posed a material risk to NAMPAC's long-term profitability and viability. It was already operating in a market where its profits were under strain and its competitors were sort of getting, the competitive edge on them. And also they were being hammered and their share price fell. So because of this increase in liability, what NAMPAC decided to do was exercise their discretion in terms of the clause in the policy. And what it did is it addressed a letter to the employees, it referred them to the clause in the policy, and it informed them of the reasons for why it was considering making this decision, which was really in an effort to save, the long-term profitability of the business and to ensure that there was a sustained organization for the employees to work in. In addition to this, what it did is it offered to buy out the majority of the employees' post-medical aid retirement liability. So what that meant is that they paid them a cash lump sum and the employees waived their rights to that entitlement once they retired. But there were approximately 210 employees who weren't happy with this and insisted that they wouldn't accept the cash buyout. And they ultimately took the labor court to, the NAMPAC to the labor court and alleged that there had been a breach of contract and that NAMPAC's decision to cap the benefit was an unfair labor practice. So very quickly, what the labor court found is that there was no basis for the appellants to state that there had been an unfair labor practice, and the labor court found that the exercise had been exercised reasonably. They then took the matter to the labor appeal court. Insofar as the contractual discretion, the breach of contract issue was concerned, what the labor appeal court said is because the contractual entitlement was subject to the exercise of contractual discretion, they didn't have a contractual right. So it was open to NAMPAC to exercise that discretion. So they didn't come right on the breach of contract. The appellants then contended that NAMPAC hadn't acted in good faith to them and that they hadn't consulted properly, they hadn't motivated the reasons for it. And most importantly, what they had said is that insofar as affordability was concerned, NAMPAC had sufficient resources to pay for the post-retirement medical aid subsidy. So basically what they said is, you can afford it, there's no reason why you can't subsidize it, we should have 100% of the entitlement. Importantly, in this case, what the Labor Appeal Court said is that insofar as the reason for the exercise of a contractual discretion is to maximize profit, this is an entirely fair and reasonable commercial rationale. So what this case does is it says that, you don't have to take it to whether or not you are able to afford something. It's sort of like the retrenchment provisions, where if the whole reason is to optimize your profitability as a business, that in and of itself is enough of a rationale to implement discretion. They also found that they had followed a completely fair consultation process that was comprehensive, that gave all of the employees the details that they needed. And as such, there wasn't any unfair labor practice perpetrated either. And that's that for that case.
Thank you so much, Lenia. Really appreciate it. I want to end off with the Churchill case on where a person's injured in the course of strike action, because I think it's an important case. Lou, if you go 3 minutes over our allotted 10:30 ending, I'm sure that you'll be forgiven because it is an important case. And I do think employers can learn a lot from it. Thank you.
So the case is Churchill versus Premier of Mpumalanga and another, and it's a Supreme Court of Appeal decision. So Ms. Churchill was employed in the office of the Premier of Mpumalanga, and her role there was Chief Director, Policy and Research. On the day in question, there was protest action at her workplace, and the protest action was over labor issues. Some of the protesters worked there, and so they had access cards and they gained access into the. She encountered some of them at various points. Once when returning from a meeting on a different floor, and again when she'd gone into a colleague's office to return some documents. Her intention was that once she'd gone to the colleague to return some documents, her and her assistant would then go home because her assistant had expressed that she was uncomfortable over the protest action. Unfortunately, when she returned to her office after returning documents to a colleague, she found that her office was locked. Now, it becomes difficult because when she was walking towards her office, she was walking behind some of the protesters. She got to her office and she discovered that it was locked, and she then swore, and she was swearing because her office was locked and she couldn't get in. Unfortunately, one of the protesters heard her and he thought that she was swearing at them. He got very upset, started shouting at her, saying, "Why are you saying these things to us?" And she then retreated and went back into the office of the colleague that she'd been returning a document at. She tried to hide behind the door. The protesters followed her. One of them tried to take her phone. He then also tried to lift her up, and two of them joined him, and they lifted her up, and they then took her to the wider group of protesters and they put her in the middle. They started swearing at her, shouting at her, pushing and shoving. Her shoes were removed. One of her shoes was thrown at her. She then suffered injuries and distress. She then sued the Premier of Mpumalanga, and she said that the Premier was liable for the injuries that she sustained in the workplace. She sued for 7.5 million rand, and she said actually she would never be able to work again because of what she'd suffered. The Premier then turned around and said, no, this was a COIDA claim in terms of the Compensation for Occupational Injuries and Diseases Act, because it was injured and sustained in the workplace. And this is what this case turned on. The Supreme Court of Appeal looked at the requirements for a COIDA claim, and they said that there were three elements. Firstly, there must be an accident. Secondly, it must have arose out of and in the course of the employee's employment. And thirdly, resulting in injury, illness, or death. The central question was whether this injury that she sustained had arisen out of her workplace. And to cut a long story short, the court said it hadn't. It said, firstly, it didn't arise out of her role as Chief Director, Policy and Research. It had nothing to do with the role that she performed at the workplace. Secondly, it didn't have anything to do with even the subject matter of the process in itself in relation to the labor issues that were being protested about. The sole reason why she was assaulted was because of the misunderstanding about her swearing and the protesters thinking that she had been swearing at them. The court gave an example of two police officers who'd shot each other at the police station because one had taunted the other about having a relationship with the other's wife. And they said the assault or the injuries took place at the workplace, but they had nothing to do with the actual duties of the person at the workplace. So they took place at the workplace, but the reasons were external and therefore did not arise out of the person's duties at the workplace. The Supreme Court of Appeal therefore said that Ms. Churchill's claims fell outside the ambit of COIDA because they actually did not arise out of her duties in the workplace. They arose solely because of the swearing, and they said that her claim had to be against the Premier of Mpumalanga directly.
Thank you so much, Lou, and we've met our time. Thank you all. I'd just like to thank those of you who have attended. I really appreciate that you spent the time with us. I'd like on your behalf to thank the panelists. Thank you very much. I think you've all presented in a way that hopefully gets the message through to everybody. Thank you, and I look forward to seeing you at the next quarterly update, which will be late in the course of the year. Thanks for your attendance.